Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was a new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing?
That's right. I think it's an 8-year cap.
What did I say?
8 years.
Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
Your Honor, the court previously refused a 5-year cap, so I'm saying the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that in her own thinking. I understand she is going to have to do some time on this, but I think that she regrets what happened and hopefully not engaged in the type of conduct that caused us to occur. It was a theft case that went awry when the officer was attempting to stop her. She didn't really approach the officer and initiate some sort of contact or with him. It was, or her, it was an unfortunate incident where, and I'm not contesting her culpability for her guilt, but where the officer reached into the vehicle and the vehicle moved forward, injuring the officer. So obviously if the court repeats 5, the court's inclined because of her criminal history to go to 6 to 8. We would just argue for 6 at the lower end. I know she has extensive criminal history, but she wanted to address it as well. Is that right? You have to say who is that?
I apologize for the situation that went on, and I wish that anybody that was involved in the case would see that I'm really serious, and to whatever you give me, I thank you for that.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well awry. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think she deserves, at the very least, a full wage.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of misdemeanor, well, page and a half of misdemeanor thefts on this pre-sentence report where you were put in the parish jail. And then you proceeded to keep doing it, so they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car, and I mean, just what went on with you and that officer is ridiculous, you know, because you're trying to steal again, and now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, find you guilty of robbery. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
Judge, I'm
You
sorry
took the
to
wrong
interrupt,
case
but
number.
I did.
You went on the robbery and we actually entered the plea on the assault. public.
Sorry, 25 DCCR 0979
That's the assault.
finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank y'all.
I just say on the record, she wanted to make sure it's not aggravated. This is not aggravated.
No, it's non-aggravated.
Okay.
All right. And we have to have that discovery certification today because the
Yeah.
case is gonna get to close
Not
down.
again, you never gave it to me.
Well, I mean, the first, when she first pled.
So do I?
You didn't give
You
it.
to give me a
Still get the credit for me being in here on this?
Yes, all the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. Good morning, you're Jerodrick Randall. And this is cause number 24 DCCR 0543. And Mr. Randall was previously in court, entered pleas of true and a motion to revoke probation. Pled true to counts 1, 2, 4, 5, and 7 and 8 on probation for the first degree felony offense of aggravated robbery. And I've received the pre-sentence report update. Have you all had an opportunity to review that?
We have, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
No, Your Honor.
Well, Judge, I noted probation's opinion that continuing on probation may not be a good idea. And I know we'd agreed on ISF and an attempt to keep him from being revoked. I understand if the court feels differently.
I didn't know that that was an agreement, and if it was, I show that you are asking for that, but I didn't think
And
the state.
I think what I
that
stated was I wanted to see the PSI
Yeah,
and get an idea of what has
The
really
new-
happened or not happened on probation.
well, he pled true, I mean, on probation for a case, an aggravated robbery that involved shooting out the window of a car at someone after having stolen stuff from that person. New offense, pled true to being arrested for unlawful carrying a weapon and evading arrest or detention. So, I'm not inclined based on, you make argument, Mr. Rojas?
Yeah, Judge, and my understanding was that it wasn't agreement for ISF, but and if it wasn't, then obviously the court can do whatever the court feels is appropriate.
Can you look, pull up that paperwork? What was the date of, it's not finalized, so the plea paperwork should still be somewhere on the tablet.
26.
If you can get 826 pulled up, do you know how to do that? And send it to me, send his paperwork to me, please. And if that's what y'all's understanding and you need some time to prepare for a hearing, I can reset it for a couple of weeks, if you want to do that as well. But let's see what the paperwork said first.
I think we discussed it, and I said I want to wait and see what PSI says. Let's double check.
Okay.
Yeah.
It is marked off on an agreed punishment recommendation, ISF cognitive, but it doesn't say wait or anything like
Okay.
that, but I don't know that I'm inclined to do that. I mean, what is the status of, are those cases down in misdemeanor court?
They're still pending, Judge. He's been appointed, Mr. Cole, to be his attorney, and I talked with him about the issue. He's inclined to go down and plead those cases once this is all taken care of.
I would like to know, at least see a PC on that new arrest.
I
If you
it
have
here,
it, you do?
Yes, Your Honor.
Any objection to me?
No objection.
Doing that? No. On probation for an aggravated robbery. And if I recall, I don't know that it was ever on, when I tried to go back and see, nobody really said or could tell for sure who shot out of that car that night. But if I'm correct, I feel like Mr. Randall, who was in the back right passenger, was potentially, it was out of the back.
Judge, I feel like because I remember this case, there was four individuals in the car.
Did
I
anyone?
don't think I would have lowered his to a non-aggravated if I believed that he was the shooter in that case.
They did gun residue, Judge, and there was no gun residue on Mr. Randall's hands.
Because it is a non-aggravated robbery, is what it is,
Okay,
what he's on probation for.
but
He was in the
still
car.
in, I mean, still in out of
Breaking in.
other, breaking into vehicles and,
Multiple vehicles.
yeah. No. And then here we are, May 3rd, so less than a year after being placed on probation, riding around, smoking pot with a gun, and when you got taken out of the car, ran from the cops. No. Go ahead, you can make argument.
Judge, my intention was to come in and ask to follow the agreement for ISF. It doesn't appear that the court's willing to do that. I would point out that this is an offense that happened when Mr. Randall was a relatively young man. He's still a young man. He is the father of a young child. I think he's a 3-year-old. 9-month-old child at home, Judge. He is obviously making some bad decisions in his life, going all the way back to the original offense date. And that was why I thought ISF would be maybe helpful to him to give him some information to help him redirect his life, make better decisions in his life for himself and for his daughter. He's a pleasant young man. Every time I go talk to him, he's a really nice, pleasant to deal with. He's never had any blow-ups here in court that I can recall. He's had maybe some jail incidents. I think he threw some soap around one time and some wardrobe incidents. But other than that, I think he's been well behaved in jail. I would ask the court that if ISF is not going to be possible in this case, that you consider doing something towards the lower end of the punishment range. I don't know that. And again, Judge, I think that's why I think ISF would be better for him. We can send him to prison right now for whatever amount of time, but if he doesn't get the help and the education that he needs, he's going to come out and be the same way, even worse. So,
Judge, I'm sorry to cut you off, Mr. Ross. I'm showing that 2 new cases were received last week by my office concerning the exact same UCW and evading from July 13th, which is not alleged in the motion. If we need to amend to add those, or if you want to address those.
Another arrest?
That's what I'm showing, Your Honor.
What's the-
2 more pending, not yet filed misdemeanors for evading,
This is May 3rd.
yeah, a different offense date. So if we want to take some time to, so I don't have a probable
Absolutely.
cause available to me,
Yes.
but I can get that, obviously. If we can take a week or so to file an amendment.
Let's go ahead. I'll probably, just based on, court schedule, I'm going to, I want that back.
Yes, sir.
I'll, let's reset it about 3 weeks. And if there is in fact a new arrest, I would like that.
Certainly.
In the
What I'll
motion.
do is file an amendment to reflect any new offenses or charges, Judge.
Yeah, that'll change everything potentially. So, yeah, let's see where we get with that. Go back with the bailiff. You probably need to talk to hey, Mr. Randall, also, you need to talk to Mr. Rojas. You need to tell him everything that's going on. He doesn't need to be surprised here in court. If you've been arrested again for something, y'all should be talking about that.
Thank you.
Thank you. Thank you, Mr. Nichols.
1 through 8 are the same counts on each. 9 and 10 are different on each.
We have. Great, we agreed to ban count 4, that's the 10.
I'm printing the other one too, just because it's gonna be hopefully easier and hopefully it'll print. It should be on its way. All right, sir, in cause number 24, DCCR 1791, I also have a motion to revoke your unadjudicated probation. This one shows you were placed on probation September 24th of 2024 for theft of a firearm, a 3rd-degree felony, and that was also a 5-year deferred probation. Is that correct? Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of unlawfully carrying a weapon May 12th of 2025 in Jefferson County, Texas, and is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County, Texas, and is that true or not true?
True.
Count 3 alleges that you committed the offense of a minor in possession of alcohol May 25th of 2025, and is that true or not true? And then the state is abandoning 4, correct? In each case. Count 5 in each case alleges that you committed the new offense of resisting arrest or transport May 27th of 2025, and is that true or not true? Count 6 in each case alleges that you failed to report as directed to the probation department February 10th and May 15th of 2025, and is that true or not true? Count
Just technical, so we can.
All right, state abandons 7 through 10 in each case.
No objection.
Did you enter your pleas of true in each case to counts 1 through 6? I'm sorry, minus 4. So 1 through 3 and then 5 and 6. Did you plead true to those freely and voluntarily? And did you plead true to those counts because they're actually true? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've reached in each of your cases, that you will be waiving or giving up any right to appeal? State tenders number 1 in each
No
case.
objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your pleas of true in each case freely and voluntarily to counts 1 through 3 and 5 and 6. Find those counts true. Find sufficient evidence in each case to find you guilty. And cause number 23, DCCR 1801, finds you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 24, DCCR 1791, finds sufficient evidence to find you guilty, and at this time finds you guilty of theft of a firearm, third-degree felony, sentence you in accordance with that agreement to a term of 5 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you in each of these cases trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you, and you need to listen carefully to this one because I'm not sure what's going on with you and all this gun stuff. Apparently you think it's cool to steal guns, have guns when you're not supposed to, and it's landed you now going to prison at, how old are you? 20 years old. You're going to prison because you can't keep your hands off guns, really. So because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. If you possess a firearm or ammunition, charges could be filed against you, and those charges are third-degree felonies. So it's no more UCW, unlawful carryings. It's a third-degree felony, felon in possession of a firearm, because you're now a felon. Do you understand? If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, I'm handing you the trial court certification in that document now. I'm also going to sign, as part of the agreement, a dismissal in cause number 25 DCCR 0868. All right, you can go back with the bailiff. And so Mr. Hancock is charged in 25 DCCR 0737 with evading arrest or detention with previous convictions. Cause number 25 DCCR 0738 with continuous violence against the family. And then there's a third case. Those both have offense dates of April, well, the first one is April 22nd of 2025. The second one is April 26th of 2025. And then in cause number 25 DCCR 1233, there's a new evading arrest or detention with previous convictions from August 5th of 2025 that has now been indicted. And Ms. Holmes has filed motions in the first two cases asking that I reduce Mr. Hancock's bonds, which are currently set at $100,000. It looks like there was a court date on July 22nd of 2025 that Mr. Hancock missed, and so that was when those bonds were increased.
On July 22nd?
Mm-hmm.
Okay.
And then, so he missed court on that date. So there it was, before that, there was an AFRS that was filed by the bondsman to get off the bond. But when he didn't show up, the bond forfeiture overrides that. And so that was the bond forfeiture. And then also, since then, there was a request for an emergency protective order. Oh, that was just filed in the case. Okay, it looks like that was from back in the arrest on, where's the date? April 26th. Okay, so I'm also reviewing jail incident reports that I have received. Have you had an opportunity to review those? Yeah. Why don't you take a look at those, and then before you try to make arguments on behalf of your client who's making things very difficult for you, y'all can go review those, and then we'll come back and discuss
Judge,
the
I think if you
bond.
just let me review his criminal history, the decision will be very easy.
I've already know what I'm gonna do, but I'd be glad for you to do that as well.
Yeah,
Okay.
he's habitual on this continuing violence against the family case. He has a total of, I believe, 10 prior felonies. And on these two evadings, the state jail and evadings with prior evading convictions, he has a total of 7 evadings. And the most recent one was picked up when he was arrested in August while he had warrants for these pending cases. His priors that are not evadings include firearms, drugs, and burglary.
Okay. Ms. Holmes?
He had only been off parole about 2 months before the new offense date in April.
What is that? Let me look at something else that's new. I want to see what the bond is set at on the new case, 25 DCCR 1233. Because honestly, based on everything I'm seeing, I'm not sure the bonds are satisfactory. We'll see. So Ms. Holmes, any,
So, Your Honor, I was provided some documentation. Apparently, Mr. Hancock, did go to the hospital, in July, which I believe at the time he did provide that documentation to the bondsman. I'm not sure if he was aware that an AFRS had been filed at that point. He is aware that he needs to behave in the jail.
really, you're aware of that? How old are you?
I'm 36.
You're 36 years old, so you needed to come here today and have her tell you you need to behave in jail?
No, no.
This is ridiculous. These people are just going to work and trying to do their job. That's all. You know, I mean, that's what the rest of us do. We go to work, we do our job, we go home, we live our lives, and we don't have punks like you acting like this and treating us this way when we're at our job. The way you have spoken to the officers, the female, they disrespect you first. You think you earned their respect? You're in jail. You follow the rules. Their job's just to do their job. If it's time, you don't get to make decisions in jail. You don't get to decide when you turn the lights on and off. You don't get to decide when you go to bed or when you eat. It's not your decision anymore. That's what happens when you continue to violate the law. You've lost your right to make those decisions. So it's their decision to try to keep everybody in order out in the jail the best they can. And the way you have spoken to them and threatened them is actually a violation of the law, and you could end up with more cases for threatening a correctional officer. So just keep going, keep stacking it up. I'm sure a jury later will love to hear all of that. They'll love to hear it. You're looking at 25 to life on one of your cases. Keep it up. Let's see what happens. Because a jury will see all of this. And if you think I'm going to take some great deal that they're going to negotiate, or you think Mr. Nichols is going to give you some great deal, it's not happening. So you're old enough to know better. I'm going to deny the motions for a bond reduction in cause numbers 25 DCCR 0737 and 0738 based on several factors: your criminal history, the fact that you did miss court, the fact that your bondsman had already filed an AFRS, your jail incident reports. I am also going to find in cause number 25 DCCR 1233 that your bond is insufficient. And in that case, I'm going to raise your bond to $100,000. A condition of all of these bonds, if you make them, will be that you will be required to wear a GPS monitoring device, and you will be on house arrest. So if you make these 3 bonds, you will be on house arrest. You're not allowed to leave your house unless you have my permission. And you will be also ordered, and it should already be in a bond condition in cause number 25 DCCR 0738 to have absolutely no contact, no communication at all with the complaining witness. Do you have that name handy?
I do, Your Honor.
Janaisha Butler.
Janaisha Butler?
Jamaisha.
Jamayssha.
So you cannot have any contact whatsoever with that person. Do you understand? That also includes when you're in jail. So there's no sending messages through that email system or anything like that to her through anybody else. That'll be a violation of your bond, and your bonds will end up raised even more. You understand? All right, I'll reset it for a sentencing, for an announcement. We'll deal with all of the cases at that time.
Thank you, Your Honor.
Thank you. Okay. Can I get both of the MTRPs? Kim, would you print the MTRPs on each case for me? Or they start on one and I'll get the other. It's just. I haven't started doing any yet. I'll do 41052.
Yes, ma'am.
Give me just a second to get this pulled up. All right, sir, are you Cody Dent?
Yes, ma'am.
And will your client waive the formal reading of the indictment and the motions?
He does, Your Honor.
Okay, so the new cases get dismissed.
That's right.
So we're just going on the two MTRPs.
Yes, Your Honor.
His signature, Mr. Dent's signature is missing on one of it.
Mhm.
You have him sign right there, please.
Oh, that's me.
Oh, you. Your signature's missing.
Yes, ma'am.
You didn't find it? Hold on, I'll do it. I printed one already. All right, it's coming. I printed it. That's right. All right, Mr. Dent, in cause number 22-41052, I have a motion to revoke your community supervision. Shows that you were placed on probation February 15th of 2023 for the state jail felony offense of theft of property. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
And then in cause number 13-17772, I also have a motion to revoke your, well, in this one, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation December 14th of 2015 for obstruction or retaliation, a 3rd-degree felony. And that was a 5-year deferred probation that's obviously been extended. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the new offense of burglary of a building May 22nd of 2025. And is that true or not true?
Not true. True.
So is count 1, the burglary of a building, true or not true?
True.
Okay. Count 2, in each case alleges that you failed to report as directed to the probation department May 6th of 2025. And is that true or not true?
True.
Count 3 in cause number 22-41052 alleges that you are $7,985 in arrears in payments of restitution to the victim in that case. And is that true or not true?
True.
Count 4 in that case alleges that you're also behind in your court-assessed fees in the amount of $5,207. And is that true or not true?
True.
Did you enter your pleas of true to all of the counts in both cases freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed those, did you go over them with Mr. Samuel?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've reached with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case, or they're admitted in each case. Is there any evidence that Mr. Dent is not competent now? I know there were some issues. We've had some examinations. Is there any evidence of?
No, Your Honor.
All right. Then I'm going to find in each of your cases, Mr. Dent, that you entered your pleas of true freely and voluntarily. And cause number 17772, find those counts true, 1 and 2 true. Find sufficient evidence to find you guilty, and at this time find you guilty of the 3rd-degree felony offense of obstruction or retaliation. Sentence you in accordance with your agreement to a term of 2 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 22-41052, also find that you enter your pleas of true freely and voluntarily. Find counts 1 through 4 true. Find sufficient evidence to revoke your probation, and at this time revoke your probation and reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time, and I will sign a dismissal as part of this agreement in cause number 25 DCCR 0807. I'm going to hand you in each of your cases the trial court certifications that shows that these were agreements that I followed, so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishments I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Samuel. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Good morning. You're Juan Sanchez? And Mr. Sanchez is on probation in cause number 1830854 for the offense of driving while intoxicated, 3rd or more. Was previously in court, entered pleas of true to counts 1, 2, and 3 in that motion to revoke his probation. And there was an unagreed, there was no deal, and I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, I have.
And I have received some objections filed, comment and objections filed by Mr. Franklin. Mr. Nichols, does the state have any objections or corrections to the updated report?
Not to the report, Your Honor.
Okay. And so with regard to Mr. Franklin, specifically, with regard to number 1, that comment in there by the probation officer with regard to that it's unlikely that it was the first time, I'm not really going to take that into serious consideration. So that's not something that's going to make a big difference in what I do today or not do. So that one, I guess if it's an objection, that can be granted. With regard to number 2, which has to do with a note in the records that you were able to look at with Officer LeBlanc asking whether or not a naturalized citizen based on their criminal history could still be potentially denaturalized and deported, and that has some type of race bias. That is also not something that is going to impact my decision, I think, as far as what I'm going to do in the case. I understand your position. Honestly, with the criminal history, which I know is another objection, we'll get to that and what's going on. I don't think it's improper to ask those questions, and I don't see anything else, especially she even put some positive things that he's done in this updated report, so it's not all negative. So I don't think there's a clear sign that there's some kind of racial prejudice or anything like that. So that's overruled. with regard to the fact that his prior convictions are inadmissible hearsay and too remote, in any motion to revoke probation or any case, prior offenses could potentially not be admissible for purposes of enhancement or sentencing in front of a jury. But as far as going into, especially when it's a driving while intoxicated, which requires prior offenses to get where we are, I think it is imperative on me to understand the criminal history, understand when those were, understand the remoteness of some of these, but it doesn't take away from the fact that you have to have those prior driving while intoxicated to get where we are now. And so I'm going to overrule that objection with regard to the prior convictions. Any witnesses today by either party? Does anybody have any witnesses?
I have no additional witnesses, Your Honor.
Your Honor, we previously submitted letters of support.
Yes.
And we believe those are in the record, and the court has reviewed those. I just
Yes.
wanted to note, for purposes of today, that we have filed those. They have been reviewed by the court, and we hope the court has taken those into consideration in considering sentencing as well.
I will, and I did, and let me pull them up again just because I think that's been,
So specifically, they were not admitted for this purpose. They were admitted for bond.
okay, that's right, thank
For
you.
purposes of bond.
Okay.
However, the letters of support, the
same,
information in
sure.
them speak to my client's character and
Yes.
his support by the community.
I see them right here, and I did review them obviously for that, and we'll take them into consideration for this hearing as well.
Thank you, Your Honor.
Anything else?
Your Honor, just in response to the analysis of the court's overruling of the objection, we would point out, as noted in the PSR, there is a substantial time in between the prior convictions and the current one for which he's on
Sure.
probation. And we hope that the court was able to look at that and consider that from 2001 to 2018, there was
Yes.
a major gap. And then by all accounts, by the admission of the probation officer, Mr. Sanchez has had minimal violations, was not a supervision problem, made efforts to be in compliance with probation. And although he did plead true to the current violation, he has shown 5 years of continued compliance. And we ask that the court consider the gap in history, the 5 years of compliance, as factors to keep him on probation.
Thank you, Mr. Franklin. Mr. Nichols?
Your Honor, this case was originally pled as an 8-year cap. And I'd argued for pen time at its original sentencing 6 years ago. I'll acknowledge he's been mostly done well on probation except for the new offense and the new violations that are alleged that he did plead true to. And I agree that his criminal history, while somewhat extensive, is rather remote. So I think those factors give the court enough information to make a decision. I am in favor of revocation just because it is another DWI offense, Your Honor. But as far as the length of time, I think the court has enough information to make a just decision on that.
So, Mr. Sanchez, the issue, I understand Mr. Franklin's argument as well as Mr. Nichols. You did have a substantial amount of time where you were able to not drink and drive. The history is old, but then again, you started it up again, in my opinion. You got this DWI, so you had, there's a couple back in 1995, and then there's one in 2000, and then you had this one in 2018, and now we have another DWI that you have admitted to in another county where you were driving a vehicle without the interlock and under the influence. And at this point, I feel like we're all lucky that you have not, that we're here on a DWI, not an intox assault or an intox manslaughter or something like that. At some point, you've got to figure it out. You're on probation for the same offense. So I'm not inclined, and I don't think it's in the best interest of the community for you to remain on probation. I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. I am going to take some of the good things that you've done in the length of time into consideration. I had initially marked on this pre-sentence report that I should probably give you the full 10. Mr. Franklin makes some good arguments with regard to the length of time that you went without being in trouble. It looks like you did well with some things on probation, but the main thing, you didn't. And so at this time, I'm going to sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you a trial court certification. I need y'all to sign this real quick, Mr. Franklin, that shows that this was not an agreement. So you do have some rights to appeal. Once y'all sign that, I'll get, tear off that bottom copy for y'all if y'all signed at the
Yes, ma'am.
bottom. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, then you can talk to Mr. Franklin. And I'm going to go back. I'm not sure if I'd said it exactly properly. I am going to reassess your punishment because you were already assessed a 10-year term. Reassess that punishment at 7 years. And here's that firearm, Mr. Franklin.
Thank you, Your Honor.
This is just gonna go, this is to go in the pile after trial, yeah. Let's see. And the bottom 2 copies are y'all's if you wanna tear those off.
Okay. I think you pressed very hard, Judge.
That's okay, as long as my signature came through, I'm okay, because I get the top 2 with his on it. Give me one more of those, there's 4.
I'm so sorry.
Nope, you're good. Perfect, thank you. All right, sir, you can go back with the bailiff.